significant development. The Kerala High Court, presided over by Justice K. Babu, has ordered the consolidation of two separate trials involving charges of sexual assault and abetment of suicide against the single accused. The order was issued on Wednesday, the 24th day of May 2023, in a criminal miscellaneous case. The case is titled JITHIN versus State of Kerala. The brief facts of the case are as follows. In 2021, a 17-year-old girl was found hanging in her family home. The case was registered under Section 174 of Code of Criminal Procedure. The charges were later modified to include Section 305 of Indian Penal Code and Section 3, subsection 2B of SC/ST Act. Based on allegations that the petitioner encouraged the girl to commit suicide. A post-mortem examination revealed that the girl had been sexually assaulted when she was under 17 years old. As a result, on June 16, 2021, a case was registered charging the petitioner under Section 376(2) of the IPC and Section 4, read with Section 3A of POCSO Act. The petitioner in this case faced charges under Section 305 of IPC and Section 3, subsection 2B of SC/ST Act before the Sessions Court in Talasheri. In addition, he also faced charges under Section 450 and 376(2)(n) of IPC, along with various sections of POCSO Act, the Information Technology Act, and SC/ST Act before the Additional District and Sessions Court 1 in Talasheri. The petitioner's counsel argued for a single trial, stating that the alleged acts were part of the same transaction. The counsel claimed that the separate trials by different courts would unfairly prejudice the accused and violate Section 220 of CRPC. They referenced the case of State of Karnataka versus M. Balakrishna to support their position. On the other hand, the learned public prosecutor argued that, based on the given facts, the alleged acts should not be considered part of the same transaction. It was contended that the acts were distinct and different from each other. The court relied on the judgments of Mohan Babita versus State of Bihar and Anjal Chaudhary versus State of Uttar Pradesh. Section 220 of Criminal Procedure allows for the joinder of charges of offences committed by the same person, provided they form part of the same transaction. The determination of whether acts constitute the same transaction depends on factors such as commonality of purpose or design, continuity of action, proximity of time, and unity of place. There cannot be a universal formula for determining the same transaction, and each case must be decided based on its specific circumstances. In the present case, the acts alleged in the case, that the sexual assault and rape were committed between December 2020 and February 2021, while the acts alleged in the case 2, that is threats and harassment leading to suicide, were committed in June 2021. The acts were not proximate in time, lacked continuity, and did not demonstrate a community of purpose or design. Therefore, they do not constitute the same transaction. The accused does not have a vested right to seek joinder of charges, and the court has discretion to try the offences separately. The petitioner's request to quash the final reports or try both cases together is not supported based on the facts and principles discussed, and the petition was dismissed. Thank you.